My name is Hugh Wood, and I have been a systems architect at Cormier Tech for the past 26 years. I'm 45 now, and for more than 2.5 decades, I dedicated my professional life to designing and maintaining the core software systems that have become the backbone of this company's operations. These systems, my systems, are valued at over $420 million, a figure that reflects not just the complex architectures I developed, but also their critical role in generating consistent revenues and operational efficiencies for the company. Over the years, I built and refined these systems meticulously, focusing on reliability, scalability, and innovation. I am known among my peers and superiors for my methodical approach and rigorous attention to detail, particularly in documentation. Every line of code, every system diagram, every update was archived and cross-referenced to ensure clarity and maintainability. This reputation was well-earned and sustained by decades of consistent performance and strategic foresight. That morning, 7 a.m. sharp, was when everything changed. I was in my office reviewing a new proposal for system enhancements when Jason Cormier, the CEO's son and currently serving as interim CTO, walked in. His demeanor was abrupt, almost smug, which immediately caught my attention. Without the usual preamble or courtesy, he informed me that my employment was terminated effective immediately. No warnings, no transition period, just a curt, "effective now." The timing was no coincidence. I was just 95 hours away from receiving a $175,000 bonus, a sum tied directly to patent vesting schedules for our proprietary technologies. This bonus was not a trivial amount. It was recognition for my contributions to patented innovations integrated within our systems. Additionally, the patents themselves were on a vesting timeline, with critical clauses triggered by continued employment through specific dates. Hearing this, my first instinct was to maintain composure. I replied simply and professionally, "Understood." Inside, however, my mind was already racing. I had anticipated that there could be internal politics and cost-cutting maneuvers ahead of the company's impending merger, but being blindsided this close to my bonus payout and patent vesting was a calculated move. Jason's decision to terminate me at this precise moment was clearly designed to prevent those payments and rights from materializing. Despite the emotional impact, I knew reacting impulsively would only work against me. Instead, I began to methodically process the implications. I mentally ran through the details of my employment contract, patent assignment agreements, and the system's architecture dependencies. I reflected on the fact that the systems I developed are so integral that they underpin much of Cormier Tech's value proposition. My knowledge isn't easily transferable. I hold passwords, administrative access, and have comprehensive documentation that no one else fully understands. This gave me leverage. I also knew from my contract's fine print that certain clauses could work in my favor, especially those relating to patent rights if terminated prematurely. My expertise in intellectual property management and contract law, skills honed over years of working closely with legal and patent teams, equipped me to approach this professionally and strategically. As I packed up my workstation, I took care to back up all files I had access to, securely copying system diagrams, code repositories, and email correspondences relevant to my compensation and intellectual property rights. I was aware that any misstep now could jeopardize what I was owed, and the ownership of the patents tied to my work. My immediate priority was to preserve evidence and documentation. I also began drafting a mental outline of the next steps, knowing that I would need legal counsel to navigate this complex situation. At that moment, the clock was ticking, not just for my bonus payout in 95 hours, but for the ownership and control of technologies that represented millions of dollars in company assets. Jason's move was aggressive, but not foolproof. I had spent years creating a web of professional safeguards and contractual protections. This was not the time to panic. It was the time to apply my strategic thinking, professional discipline, and mastery of the systems and contracts that had made me invaluable to Cormier Tech. My calculated "understood" was not an acceptance of defeat. It was the calm before I launched a methodical response that would leverage every resource available to me. Over the span of 26 years at Cormier Tech, My role evolved far beyond just writing code or managing servers. I was entrusted with building and sustaining the company's core enterprise systems that generate well over $150 million in annual revenue. These platforms form the backbone of multiple product lines, customer management solutions, and operational workflows. My work fundamentally shaped how Cormier Tech delivered value to clients and maintained a competitive edge in the market. From initial architecture design to iterative enhancements, I ensured these systems were reliable, scalable, and secure, supporting everything from transaction processing to data analytics. Throughout my tenure, I consistently prioritized not only functional excellence, but also cost efficiency. By optimizing processes and automating manual workflows, I contributed to millions of dollars in annual savings on operational costs. These efficiencies translated directly into higher profit margins and enhanced the company's valuation. For example, when we undertook the migration to a microservices architecture in 2012, I led the initiative to modularize legacy code bases. This effort reduced downtime during deployments by 40% and improved system responsiveness, which was critical for high-volume clients. Such improvements were meticulously documented in design specifications and system diagrams, which I maintained with methodical precision. In addition to technical achievements, my work generated significant intellectual property assets for Cormier Tech. Over the years, I developed and patented 12 proprietary technologies integral to our systems. These patents cover innovative methods for real-time data synchronization, fault-tolerant network protocols, and secure multi-factor authentication mechanisms. Each patent is tied directly to compensatory bonuses that vest upon continued employment through specific contractual milestones. These agreements were negotiated carefully with the company's legal department, binding both parties to clearly defined terms regarding ownership and compensation. The patent's value is reflected not only in our product differentiation, but also in the company's overall valuation, a figure that has climbed to over $420 million, largely based on these proprietary innovations. In 2015, I earned the promotion to lead architect, a role that expanded my responsibilities to overseeing all system development lifecycles and managing a team of engineers. This position required a deep understanding of both technical and business considerations. I implemented rigorous backup protocols, created comprehensive archives of source code repositories, and developed detailed system architecture diagrams that map every component and dependency. These internal resources are critical. They serve as the company's technical memory and knowledge base. Importantly, I am the only person with full access to certain administrative credentials and the sole author of several key modules, making my role indispensable. I'm also known within the company for my meticulous documentation practices. Every update, bug fix, or architectural change is logged in version control systems with descriptive commit messages and linked to corresponding project tickets. System diagrams are updated quarterly and cross-referenced against deployment records. This level of detailed record-keeping means that even if I am unavailable, the team should theoretically maintain continuity, though in practice, my deep knowledge and contextual insights remain irreplaceable. This reputation for reliability and thoroughness has earned me trust across departments from product management to legal counsel. My expertise extends beyond the technical aspects into intellectual property management, a discipline I learned through close collaboration with the company's patent lawyers over the years. I have always been vigilant to ensure that all inventions and innovations are properly documented, assigned, and protected under our agreements. The patent vesting schedules and associated bonus structures were designed to incentivize long-term commitment and protect the company's rights in these assets. However, they also include clauses that protect me as the inventor, particularly in cases of premature termination, though these nuances are often overlooked by management. Despite this, my value to the company has also made me a target. My comprehensive knowledge, control over critical system components, and the financial implications tied to my compensation have created friction, especially with newer leadership eager to cut costs in preparation for the looming merger. Over the years, I've noticed subtle shifts. Meetings where my suggestions were dismissed requests for handing over responsibilities without adequate transition, and increasing pressure to justify the bonus payouts. None of this was overt until that morning when Jason delivered the termination notice. Up until then, I was actively involved in planning system enhancements and collaborating on patent filings. As I packed up my office that day, I wasn't just removing personal belongings, I was securing the foundation of my professional legacy. I backed up critical files, including source code repositories, system architecture diagrams, and email threads outlining my bonus schedules and patent assignments. I knew that preserving this evidence was paramount, not only for my own protection, but also for enforcing my rights. Any gaps or losses could be exploited to undermine my claims. I also reviewed my employment agreement one more time, paying close attention to clauses about termination, bonus forfeiture, and intellectual property rights. The legal language, dense as it was, contained the tools I needed, if I used them correctly. In hindsight, the systems I built represent more than lines of code or software modules. They embody years of accumulated expertise, innovation, and trust, elements that no new hire could instantly replicate. My work has tangible monetary value, reflected not only in revenue figures, but also the company's patent portfolio and strategic assets. This made the abrupt termination all the more egregious, but it also offered strategic leverage. I was already formulating a plan to assert my rights professionally and methodically, confident that my documented contributions and contractual protections would support me. This was just the next phase of a calculated professional battle, one requiring discipline, patience, and a deep understanding of both technology and law. Jason Cormier was 33, young and ambitious, the kind of executive eager to prove himself in the family business. As the CEO's son and interim CTO, he carried a heavy weight of expectation, but also a certain impatience. His approach was more aggressive and cost-focused, compared to the more measured leadership I'd seen in previous decades at Cormier Tech. The impending $420 million merger added pressure to tighten budgets and streamline operations, creating a perfect storm for rash decisions. Jason saw room to cut expenses quickly, and I was squarely in his crosshairs. His motivation was clear. My $175,000 bonus, tied explicitly to the vesting of a dozen patents integral to the company's flagship systems, represented a significant payout he wanted to avoid. From his perspective, eliminating that liability just days before the vesting deadline would improve the company's financials ahead of the merger, making Cormier Tech more attractive on paper. This short-term gain, however, overlooked the complex contractual and legal framework underpinning my employment and intellectual property rights. Jason's plan was blunt and direct: terminate my employment abruptly, effective immediately, thereby preventing the bonus payout and halting the vesting process altogether. He intended to bring in a less expensive, less experienced engineer to take over my responsibilities, or at least attempt to. This younger engineer lacked my deep familiarity with the company's proprietary systems, the administrative credentials, and the nuanced understanding of the interdependencies I had painstakingly documented over 26 years. Jason's assumption was that he could replace me swiftly and with minimal disruption, saving money without fully appreciating the risks involved. What Jason failed to grasp was the critical contract clause embedded in my employment and patent agreements. This clause explicitly stated that if my employment was terminated before the patent vesting date, all rights to the patents would revert back to me, the inventor, not the company. The company's legal team had included this protection to ensure inventors retained ownership in cases of premature termination, a safeguard against exactly the kind of maneuver Jason was attempting. It was a subtle but powerful clause that Jason either overlooked or chose to ignore, underestimating its potential impact. Additionally, I was the sole custodian of essential system passwords, encryption keys, and detailed documentation that no one else at the company fully understood. Over the years, I had developed comprehensive system architecture diagrams, version control logs, and internal memos outlining the proprietary nature of the codebases. These were not just technical artifacts. They were legal and operational assets that, if withheld or controlled strategically, could significantly influence the company's operations and the merger process. Recognizing the gravity of this oversight, I reached out immediately to Linda Barrett, a seasoned employment lawyer with expertise in contract law and intellectual property disputes. Linda had been a trusted advisor during several patent negotiations and was well versed in the nuances of my contracts. Together, we began dissecting the termination notice, the timing relative to the patent vesting schedules, and the specific language of the patent assignment agreements. Linda confirmed my suspicion. Jason's termination strategy, while aggressive, was fraught with legal peril due to the reversion clause. Our initial discussions focused on identifying all leverage points. The unpaid $175,000 bonus was an immediate financial claim. More importantly, the patent rights reversion could potentially block the company from using critical proprietary technologies unless proper licensing agreements were renegotiated. This raised substantial risk for the merger, which required clear and uncontested intellectual property ownership for due diligence and regulatory approvals. We also noted the broader corporate governance implications. As interim CTO, Jason's unilateral decision to terminate a key employee without board consultation or HR protocol raised red flags. The absence of severance and bypassing of standard termination procedures suggested a deliberate attempt to circumvent contractual obligations. This was not just a personnel decision, it was a calculated financial and legal gambit. On my end, I remained composed and strategic. I began a systematic review of all documentation, employment contracts, patent filings, email trails, meeting minutes, looking for evidence of Jason's intent and any deviations from prescribed procedures. I knew that a professional, evidence-based approach would be vital to countering what was essentially a politically motivated dismissal. Emotional reactions or public confrontations would only weaken my position. I also commenced securing all relevant digital assets under my control. Backing up system diagrams, code repositories, and communications relating to my bonus and patent rights was essential. This created an archival foundation to support any legal claims and to ensure I had an unaltered record in case of disputes or attempts to modify files. My deep familiarity with the system architecture allowed me to identify exactly which components were proprietary and dependent on my patented innovations. The combination of the patent reversion clause, my control over critical system documents and passwords, and the documented timeline of bonus vesting formed a formidable professional arsenal. Jason's plan to replace me with a less costly engineer neglected these strategic elements, exposing the company to operational disruptions and legal challenges that could jeopardize the entire merger. In summary, Jason's eagerness to cut costs ahead of the merger drove him to make a reckless decision to terminate my employment days before my significant bonus and patent vesting. His lack of understanding or disregard for the contractual protections in place, combined with my unique control over proprietary systems, set the stage for a rigorous professional challenge. With the support of Linda Barrett, I prepared to navigate this complex situation systematically, turning Jason's oversight into leverage that could not be ignored. This phase was not just about financial recovery, it was about defending rightful ownership of intellectual property and preserving the integrity of systems critical to Cormier Tech's future. Reviewing the termination paperwork immediately after Jason's abrupt dismissal, I noticed glaring omissions and inconsistencies that confirmed my suspicions. There was no severance offered, no goodwill gesture, no transitional arrangement, just a curt one-line notice marked effective immediately. The timing was deliberate and unmistakable. The termination occurred 95 hours before my $175,000 bonus payout, tied directly to the vesting of 12 key patents. This was not an oversight. It was a calculated effort to block that payment. My contract was explicit about the conditions under which bonuses and patent rights vested, and this timing fell deliberately short. I began a meticulous examination of the termination documents alongside my employment contract, paying special attention to clauses referencing bonus eligibility and patent vesting. The language was precise. Continued employment through specific milestone dates was a prerequisite for both. More significantly, the patent assignment agreements contained a critical clause stipulating that if my employment was terminated before the vesting date, ownership of those patents would revert to me, the inventor, rather than remaining with the company. This clause was drafted to protect inventors from losing their rights unfairly, but Jason's actions suggested he had either overlooked it or underestimated its enforceability. To confirm whether this was part of a broader scheme, I accessed my company email and calendar archives. I found a series of emails between Jason and his senior staff, dated over the past 2 weeks, discussing the urgency of cost reductions before the impending merger. One email in particular, sent 3 days prior to my termination, explicitly outlined a plan to expedite Hugh Wood's exit to avoid the upcoming bonus payout. Another message indicated that the HR department was instructed to withhold severance deliberately and to process the termination immediately, bypassing normal protocols. These communications demonstrated clear intent and coordination to block my contractual benefits. Financial records further corroborated this. Payroll documents showed that the bonus pool was approved and allocated internally, but my bonus payment was conspicuously absent from the disbursement schedule. This aligned exactly with the timing of my dismissal. I flagged these discrepancies and cross-referenced them with my bank statements and direct deposit records to ensure no payments had been processed inadvertently. Next, I turned to the patent assignment agreements themselves. Each patent filing referenced schedules and milestones tied to my employment dates. The reversion clause was unequivocal. If employment terminated prior to the vesting event, all rights reverted to the inventor, effectively nullifying the company's claim. This meant that if my termination stood as is, the company would lose the rights to the innovative technologies embedded in its core systems. Given that these patents underpin critical product lines and revenue streams, this presented a significant operational and legal risk for Cormier Tech. To visualize the implications, I mapped out the system dependencies in a detailed architecture diagram I had maintained. The proprietary code subject to patent protection was integrated into multiple flagship products and back-end services vital to client operations and revenue generation. Without clear rights to use this code, the company's technology stack faced immediate jeopardy. Moreover, I was the sole holder of several administrative passwords, encryption keys, and system access protocols related to these patents, resources not yet transferred or documented for use by other employees. I also reviewed documentation on regulatory compliance related to the upcoming merger. Public filings and disclosures required clear declaration of intellectual property ownership. Any ambiguity could trigger investigations or delays by regulatory bodies such as the Securities and Exchange Commission. The timing of my termination and the planned exclusion of my patent rights would create legal exposure for the company if undisclosed. Throughout this review, I maintained a professional mindset, focusing on the facts and evidence. I compiled a comprehensive dossier that included copies of my employment contract and patent assignment agreements, the formal termination notice and related HR communications, emails documenting Jason's plans and instructions to expedite my dismissal, payroll and bonus allocation records showing withheld payments, detailed system architecture diagrams highlighting patent-dependent code, regulatory filing guidance pertaining to intellectual property disclosure requirements. This dossier formed a multifaceted leverage framework covering unpaid compensation, rightful patent ownership, operational control of critical systems, and regulatory compliance risks. I began drafting notes on how each element could be systematically pursued, both legally and professionally. Importantly, I recognized that my response needed to be measured and precise. Any public or emotional reaction could undermine the integrity of my claims. Instead, by methodically documenting every detail and maintaining calm professionalism, I positioned myself to build a robust case that could not be easily dismissed or overturned. In parallel, I started considering how to secure witness statements from colleagues familiar with my work and who might corroborate the timeline and context of my termination. Their testimony could reinforce evidence of Jason's intent and the importance of my role within the company's proprietary systems. As the hours ticked down toward the bonus vesting deadline, I knew I had to act swiftly but strategically. Jason's attempt to block my compensation and patent rights was an audacious gamble, but one that underestimated the strength of well-crafted contractual protections and the operational realities tied to my expertise. This review and initial assessment phase was critical. It transformed my abstract suspicions into a concrete professional framework, grounded in contractual language, documented communications, and technical dependencies that I could leverage in the next phases of my response. I was no longer just reacting to betrayal. I was preparing to assert my rights with rigor, discipline, and a clear path toward reclaiming what was rightfully mine. After thoroughly reviewing the termination notice and the supporting documents, I knew that my next critical step was to engage legal expertise to validate my understanding of the contract provisions and to confirm the strength of the patent reversion clause. I promptly scheduled an immediate consultation with Linda Barrett, a trusted employment and IP lawyer who had previously advised me on patent filings and employment agreements. Linda's reputation for precision and strategic foresight in contract law was exactly what I needed to navigate this complex situation. During our consultation, I presented Linda with the termination paperwork, my employment contract, patent assignment agreements, and the email threads I'd uncovered that explicitly showed Jason's intent to expedite my firing prior to the bonus vesting date. Linda carefully analyzed the patent reversion clause, which stipulated that ownership of patents would revert to me if my employment was terminated before the vesting schedule completed. She confirmed that this clause was a potent legal tool, one that, if properly leveraged, could essentially block Cormier Tech's rights to use the patented technologies integral to their core product lines, technologies that I had developed over decades. Linda also pointed out that the abrupt timing of my termination, just 95 hours before the $175,000 bonus payout, constituted a breach of good faith and possibly violated labor laws related to wrongful termination and contractual bonuses. She emphasized that the absence of severance pay and the failure to follow standard HR termination procedures added layers to the company's legal exposure. This validated my suspicion that Jason's actions were not only financially motivated, but also potentially unlawful. Armed with Linda's confirmation, I shifted into a highly organized mode of document management and evidence gathering. I meticulously assembled every relevant document, sorting them chronologically and categorically to build a clear narrative. This included the detailed employment contract with clauses on bonus eligibility and patent assignment, the patent agreement specifying vesting schedules and the reversion clause, the termination notice and related HR correspondence, the email trail between Jason and HR personnel outlining the plan to expedite my firing, payroll records demonstrating the withholding of my $175,000 bonus, system access logs and architecture diagrams illustrating the reliance of key products on my proprietary code. I created a centralized digital repository to securely store these documents, ensuring that each file was backed up multiple times to prevent any accidental loss or tampering. Additionally, I flagged certain emails and documents as critical to highlight their evidentiary value for potential legal proceedings. Recognizing the importance of corroborating my claims, I reached out discreetly to trusted colleagues who were aware of Jason's rush to terminate me and who understood the significance of my role in managing the systems. I requested their signed written statements attesting to the timeline and context of my termination, as well as the operational risks posed by my sudden dismissal. These witness statements would be essential to substantiate the claim that Jason's actions endangered not only my contractual rights, but also the company's technical continuity and contractual compliance. Parallel to these document preparations, I reviewed the regulatory framework governing mergers and intellectual property disclosures. The Securities and Exchange Commission, SEC, and patent regulatory bodies require full transparency and accurate reporting of IP ownership during mergers. Any discrepancy or failure to disclose could trigger investigations or sanctions, potentially delaying or derailing the $420 million merger Cormier Tech was pursuing. I collected the relevant sections of regulatory guidance to reference in upcoming filings and complaints. Throughout this process, I maintained a professional demeanor, avoiding any public statements or emotional reactions. I knew that every interaction, every email, every meeting could be scrutinized and used as evidence. My strategic approach was to demonstrate unwavering professionalism, emphasizing facts and contractual rights rather than personal grievances. In my internal planning, I mapped out the leverage points that would form the foundation of my forthcoming actions. The unpaid $175,000 bonus claim, the patent ownership reversion, control over system access and proprietary documentation, and the regulatory compliance risks associated with the merger. Each of these represented a pillar of legal and professional pressure that would compel Cormier Tech to engage seriously with my claims. I also considered timing carefully. With only 95 hours until the bonus vesting deadline, it was imperative to act swiftly but methodically. Linda and I discussed filing preliminary complaints and notices to the company and regulatory agencies, ensuring that my position was formally recorded and that deadlines were met without haste-induced errors. Preparing for all contingencies, I secured multiple backups of the system files and architecture diagrams, including off-site encrypted copies. I knew that in a protracted legal dispute, control over these critical assets could influence negotiations and enforcement. This step was essential, not only for protecting my intellectual property, but also for maintaining operational integrity in case of company attempts to circumvent my claims. By the end of this phase, I had constructed a comprehensive multi-layered dossier and aligned legal counsel ready to initiate formal actions. The consultation with Linda Barrett not only affirmed the strength of my contractual protections, but also helped refine my strategic framework for the next steps. The data was clear, the evidence compelling, and the professional course ahead well-defined. Jason's unilateral move to terminate me had underestimated the robustness of the contracts and the operational realities tied to my role. The merger, the bonus payout, and the patent rights were now intertwined with a complex legal terrain I was prepared to navigate systematically. This was not just a defense of my compensation, but a strategic assertion of rights over intellectual property and professional recognition built over a quarter century. I reminded myself that patience and precision were my strongest allies now. The coming days would require measured actions, thorough documentation, and professional discipline to leverage every contractual safeguard. The groundwork was laid. Now the real contest would begin. Linda Barrett's meticulous review of my employment and patent contracts was the critical step that transformed my suspicions into actionable leverage. When we sat down together, I laid out the termination notice, the original employment agreement, the 12 patent assignment documents, and the email trail exposing Jason's intent. Linda's expertise allowed us to dissect the fine print in detail, confirming that Jason's termination violated multiple contractual provisions and legal standards. First, Linda highlighted the patent reversion clause embedded in the agreements. The language was clear and unambiguous. If termination occurred before the vesting date, ownership of the patents would revert to me as the inventor, nullifying the company's claim. This clause was drafted precisely to prevent the company from circumventing inventor rights via premature dismissals, a safeguard that Jason either overlooked or disregarded. Legally, this meant that Cormier Tech could no longer claim rights to the patented technologies integral to its core systems without negotiating licenses or risking infringement claims. Linda also pointed out that the timing of my termination, only 95 hours before the $175,000 bonus payout tied to patent vesting, constituted a breach of the implied covenant of good faith and fair dealing, inherent in employment contracts. Furthermore, the absence of severance pay and the bypassing of standard HR protocols, such as performance reviews or progressive disciplinary steps, strengthened the case for wrongful termination. These procedural violations indicated that my firing was not only financially motivated, but potentially unlawful under labor law. Together, we catalogued the specific contract clauses Jason had violated: bonus eligibility requiring continuous employment through the vesting date, patent rights assignments conditional on uninterrupted service, and company policies mandating severance and formal termination processes. Linda emphasized that these breaches created multiple independent grounds for legal action, ranging from unpaid compensation claims to patent infringement and wrongful termination suits. Beyond the contractual review, we analyzed technical documentation to support the patent claims. I provided Linda with the detailed system architecture diagrams showing that the patented technologies underpinned critical product lines generating substantial revenue. These diagrams traced dependencies meticulously, proving that disabling or losing access to my proprietary code would jeopardize company operations. This technical evidence bolstered the legal argument that the patents were not abstract assets, but directly tied to active revenue-driving systems. We also compiled a timeline of events and communications, incorporating emails between Jason, HR, and other executives, which explicitly discussed the intention to terminate me preemptively to avoid bonus payouts. This demonstrated a calculated scheme rather than an ordinary personnel decision. Linda advised that documenting this intent was vital for establishing bad faith and potential damages in litigation. Importantly, we prepared a legal strategy to leverage the patent reversion clause aggressively. Since the patents had not vested, I retained ownership, enabling me to restrict or condition the company's use of these technologies. This leverage created a powerful negotiating position to recover unpaid bonuses and enforce licensing fees. Furthermore, it introduced regulatory risks for Cormier Tech, as undisclosed contested IP ownership could trigger SEC investigations affecting the merger. Linda and I developed a comprehensive dossier to initiate formal complaints. This included copies of all relevant contracts and agreements highlighting the breached clauses, the termination notice and all related HR communications, a catalogue of emails evidencing premeditated termination to block compensation, payroll records showing withheld bonus payments, system diagrams linking patented technologies to key product functionalities, regulatory compliance documents indicating required IP disclosures during mergers. Our approach emphasized methodical documentation and adherence to legal standards for evidence preservation. We also planned to secure witness statements from colleagues familiar with the technical and operational risks posed by my sudden termination, adding testimonial weight to our claims. Throughout this phase, I maintained a professional composure, focusing on facts and evidence rather than emotion. I understood that the strength of our case depended on precision and credible documentation. Linda's detailed contract analysis and strategic counsel were indispensable, allowing me to convert a seemingly abrupt and unfair dismissal into a multidimensional legal and professional challenge with substantial implications. As a result, I was positioned not just to demand my rightful bonus and patent ownership, but also to expose the risks Jason's unilateral actions imposed on Cormier Tech's merger plans. By coupling contractual violations with tangible technical evidence, we created a formidable case that would command the attention of the company's board, regulators, and eventually the courts. This phase of building the legal and professional case was pivotal. It transformed my initial shock and betrayal into a structured, evidence-backed campaign to assert my rights. With Linda's guidance, I was ready to proceed systematically, leveraging every contractual and operational safeguard to protect my intellectual property and financial interests. The groundwork was firmly laid to engage Cormier Tech's leadership and regulatory authorities in a battle that extended far beyond a mere employment dispute. The moment had come to move beyond assessment and preparation. I had to make my claims official. With Linda Barrett's guidance, I formally served legal notices to Cormier Tech and its board of directors, invoking the patent reversion clauses embedded in my agreements, as well as my legitimate claim to the unpaid $175,000 bonus. These notices were meticulously drafted, referencing specific contract sections and backing every assertion with documented evidence. The language was professional but unequivocal. The company's unilateral termination of my employment, timed deliberately before the vesting deadlines, triggered reversion of patent ownership rights back to me and constituted a breach of contractual bonus obligations. Serving these notices was not merely a formality. It was a strategic maneuver designed to compel the corporate leadership to recognize the serious legal and operational consequences of their decision. I ensured delivery confirmations were secured. The notices were sent via registered mail and electronically to the board members, legal counsel, and executive offices, creating an irrefutable paper trail. Concurrently, Linda filed formal complaints with regulatory bodies, including the Securities and Exchange Commission and the United States Patent and Trademark Office, highlighting the company's non-disclosure of contested intellectual property ownership in its pending merger filings. These regulatory complaints were crafted to emphasize potential violations of disclosure requirements that could stall or invalidate the $420 million merger. The impact was swift. The regulatory complaints prompted immediate internal audits within Cormier Tech. I was discreetly informed by a trusted contact on the board that select members were now reviewing the legal notices and the attached evidence in detail. The risk to the merger, which required clear title to all intellectual property, had become apparent to them. I intentionally limited direct communication, allowing my lawyer to handle all correspondence. This approach preserved professional decorum and ensured that every interaction was documented and compliant with legal protocols. Meanwhile, Jason remained unaware of the full scope of my actions. His focus was still on cost-cutting victories and onboarding the junior engineer he'd hired as my replacement. I maintained my professionalism in any indirect interactions, responding factually to requests for information through Linda and submitting transition documents in accordance with company policy. Despite his belief that I was out of the picture, I was methodically laying the groundwork to disrupt the merger process by leveraging contractual and regulatory mechanisms. As I waited for the boardroom door to open at the official meeting the following morning, I felt a calm determination. My legal notices and regulatory complaints had shifted the corporate landscape. The board was now forced to confront the reality that the company's claim to critical intellectual property was legally compromised. The timing was significant. These developments occurred less than 24 hours after my notices were served, catching senior executives off guard. The atmosphere was tense but professional. No one could ignore the seriousness of the issues raised. The boardroom door slammed shut sharply at 8 a.m., signaling the start of a critical meeting where the fate of the merger and my claims would be discussed in earnest. I was not present physically, but through my legal representation and the evidence I provided, my position was unmistakably at the center of the corporate dialogue. The company's leadership now faced the consequences of Jason's premature termination decision, a decision that had inadvertently handed me leverage through contractual protections and regulatory scrutiny. At this juncture, the situation remained precarious. The merger was in jeopardy, the company's legal exposure growing, and my professional and financial claims firmly established, but far from resolved. I was strategically positioned, maintaining discipline and professionalism, prepared for the next phase where the battle over intellectual property rights, unpaid compensation, and corporate governance would intensify. The groundwork I laid, clear, documented, and legally sound, was now forcing Cormier Tech's leadership to confront uncomfortable truths, setting the stage for ensuing corporate and legal maneuvers. The immediate aftermath of my termination unfolded in ways I had anticipated, but remained unsettling nonetheless. Jason's decision to replace me with a less experienced engineer quickly revealed operational cracks that exposed the true depth of my role at Cormier Tech. Within days, system failures began surfacing across multiple product lines, the very systems I had architected and maintained for over 2 decades. These failures weren't random glitches, but stemmed from a fundamental lack of understanding and documentation on the part of my replacement. Despite the comprehensive documentation I left behind, there were critical nuances and undocumented dependencies only I fully grasped. The new engineer struggled to navigate these gaps, triggering cascading errors in production environments, delayed feature releases, and erratic system behavior. Internal incident reports logged increased downtime and escalated issues to senior management, raising red flags in quality assurance and client services departments. These technical failures translated directly into client dissatisfaction. Key accounts that relied on the stability and performance of our systems began raising concerns. I monitored internal communications carefully, professionally, through my legal team to stay informed about these developments. Emails circulated between account managers and executives, questioning product reliability and requesting explanations for outages. The reputational damage was beginning to accumulate, and I knew that the timing was critical. The company was rushing to close a $420 million merger, where operational integrity was under intense scrutiny. Concurrently, the Securities and Exchange Commission (SEC) initiated inquiries into Cormier Tech's merger disclosures. These inquiries focused on whether the company had fully disclosed contested intellectual property ownership and the abrupt termination of a key employee responsible for critical patents. The regulatory spotlight intensified as the SEC sought documents and clarifications about the company's governance practices and compliance with disclosure obligations. Jason's demeanor shifted noticeably during this period. Initially confident in his cost-cutting strategy, he became increasingly frantic, recognizing that his attempt to circumvent contractual obligations might backfire. I began receiving indirect communications through mutual contacts, requests for informal assistance, offers of consulting fees to help resolve system stability issues, even overtures to reconsider his decision. Each time, my response was firm and professional. All communications were directed through Linda Barrett, my legal counsel, ensuring a formal record and preventing any unsanctioned dialogue. On the corporate front, the board of directors delayed votes on the merger amid growing concerns about unresolved IP ownership and system stability. I was discreetly informed by a board member sympathetic to my position that internal discussions were underway to evaluate the risks I had raised. The corporate atmosphere was tense but controlled, with executives cautiously reassessing the impact of Jason's unilateral decisions. Throughout this turbulent phase, I maintained a strict professional posture. When official inquiries or requests for information came through, I responded factually, without personal commentary or emotional overtures. I continued to submit all required transition documents and access credentials per protocol, mindful that any deviation could weaken my legal standing. My goal was to demonstrate professionalism and reliability, reinforcing the legitimacy of my claims. The technical fallout underscored a vital truth. The systems I built were more than code. They embodied years of accumulated knowledge, nuanced design decisions, and proprietary innovations that required stewardship beyond mere documentation. The company's public image and operational foundation were visibly shaken without my involvement, validating the leverage embedded in my contractual protections. Meanwhile, the CEO, Martin Cormier, confronted his son privately in a meeting I later learned about through trusted sources. The conversation was reportedly intense, with Martin pressing Jason on the severity of the situation, the exposed legal risks, the regulatory scrutiny, and the jeopardized merger. The family dynamics, intertwined with corporate governance, created a complex backdrop to the unfolding crisis. In this phase, my strategy was clear: allow the natural consequences of Jason's miscalculations to unfold while positioning myself as a calm, professional architect of resolution, not conflict. The company's foundation was showing cracks where I had built strength, and the ripple effects of my termination were now impossible to ignore. The boardroom door had slammed shut at 8 a.m., the day after my dismissal, marking the start of a battle that extended well beyond personal grievances. It was now a test of corporate stewardship, legal compliance, and the integrity of intellectual property rights. The situation remained precarious. The system instability, client doubts, and regulatory investigations created a volatile mix that threatened the merger's progress. Jason's attempts to manage the fallout were reactive, lacking the foresight that had defined my tenure. I stayed disciplined, letting the evidence and contractual leverage speak on my behalf, fully aware that the next moves by the company and regulators would shape the trajectory of this conflict. Simultaneously with the mounting operational chaos and regulatory scrutiny, Linda and I took decisive legal action to transform my professional and contractual grievances into formal claims. We filed a lawsuit against Cormier Tech, meticulously outlining multiple violations: breach of contract, patent misappropriation, and failure to disclose critical intellectual property ownership within the merger documentation. The complaint was structured to emphasize how Jason's premature termination had triggered the reversion clause in my patent agreements, effectively stripping the company of rights to proprietary technologies embedded in their core systems. This legal filing was not merely reactive. It was a calculated move to assert control over the contested intellectual property and protect my financial interests. The breach of contract claim focused on the company's deliberate timing to terminate my employment just days before both my $175,000 bonus vesting and the patent vesting deadlines. Detailed references to the employment agreement highlighted the explicit requirement for continuous service through those milestone dates to secure compensation and rights. We underscored that Cormier Tech's failure to honor these clauses violated the implied covenant of good faith and fair dealing inherent in employment contracts. This positioned the dismissal as not just untimely, but legally wrongful, warranting remedies beyond mere reinstatement or severance. Our patent misappropriation allegation was particularly critical. Given the patent assignment agreement's reversion clause, my termination prior to vesting meant that ownership reverted to me as the inventor. By continuing to use the patented technologies without a valid license or assignment, the company risked infringing on my exclusive rights. The complaint detailed each affected patent, their integration into key system modules, and how their use without proper authorization constituted misappropriation. This argument elevated the dispute from an internal employment matter to a substantive intellectual property conflict, with legal consequences including injunctions and damages. Equally important was our claim addressing the failure to disclose contested IP ownership in the merger documentation. Corporate governance and securities laws mandate full transparency regarding intellectual property assets during mergers and acquisitions. We documented how Cormier Tech had submitted filings to regulatory bodies, notably the Securities and Exchange Commission, representing clear title to all patents and proprietary systems. This representation was false or misleading, given the reversion triggered by my termination, creating potential grounds for regulatory sanctions, merger delays, or rescission. By including this claim, we engaged external enforcement agencies, intensifying pressure on the company. Meanwhile, the Patent Office launched its own investigation into the validity of the patent reversion claims. Our formal communications outlined the circumstances of employment termination, the contractual clauses involved, and the timeline of patent vesting. This investigation posed a credible threat to Cormier Tech's continued use of the patents, potentially invalidating the company's assignments or requiring licensing negotiations under adverse terms. The regulatory scrutiny added a layer of legal complexity that Jason and the company had not anticipated. Parallel to these legal maneuvers, client confidence began shaking. Key customers, alerted by system instability and service interruptions after my departure, questioned the integrity of the products they depended on. Client retention teams reported increased complaints and even threats to terminate contracts pending resolution of the technology issues. This commercial pressure reflected directly on the company's valuation and merger prospects, amplifying the stakes beyond the courtroom. Under mounting pressure, Jason reached out with overtures for settlement. He proposed talks that included conditions such as my reinstatement under terms heavily favoring the company, waiving certain claims in exchange for limited consulting roles, or accepting reduced compensation. Each offer was carefully considered but ultimately declined. My response remained measured and professional. "My lawyers will be in touch." This phrase served both as a firm boundary and a signal that any further communication would be formal and documented, preserving my negotiation leverage and legal position. The board of directors, facing the convergence of legal challenges, regulatory inquiries, system failures, and client concerns, postponed the scheduled merger vote indefinitely. Internal memos later revealed that board members were deeply divided and concerned about the undisclosed IP issues and the potential fallout from the lawsuit. This delay underscored how profoundly my contractual and professional assertions had unsettled the company's strategic plans. Throughout this period, our evidence package, contracts, emails, system logs, architecture diagrams, and regulatory filings formed an unassailable factual foundation. The integrative approach combining contractual law, intellectual property rights, and corporate governance created a compelling narrative that the company's handling of my termination and patent rights was both unlawful and operationally reckless. This phase of the dispute was pivotal. What began as an employment termination evolved into a multifaceted legal and professional confrontation. By leveraging the patent reversion clause and exposing regulatory omissions, we escalated the matter beyond internal HR disputes into a broader corporate challenge affecting shareholders, regulators, and clients alike. My strategic patience, rigorous documentation and legal coordination, had transformed a calculated betrayal into a position of undeniable strength, forcing Cormier Tech to reckon with the consequences of underestimating the power of precise contractual protections and professional discipline. Jason's removal as CTO was the inevitable consequence of a series of miscalculations and failures that had become impossible for the board to overlook. After mounting legal pressure, regulatory inquiries, and operational turmoil, the executive leadership convened an emergency session to address the escalating crisis. The board recognized that Jason's unilateral decision to terminate me without due process not only violated contractual and legal obligations, but had also jeopardized the company's entire $420 million merger. His dismissal was formalized with documented internal disciplinary actions, citing breach of fiduciary duty, failure to follow corporate governance protocols, and reckless endangerment of proprietary assets. This outcome was not a personal victory, but a professional reckoning reflecting the gravity of his missteps. The disciplinary records showed that Jason had bypassed required HR consultations, ignored advice from legal counsel, and failed to ensure continuity in critical system management, errors that collectively undermined investor confidence and placed the company at regulatory risk. The board's decision to remove him underscored the seriousness of adhering to corporate governance standards, especially during high-stakes transactions. Simultaneously, the planned merger collapsed under the weight of these unresolved issues. Shareholders received formal notices explaining the indefinite postponement and eventual termination of merger negotiations. Financial analysts quickly recalibrated Cormier Tech's valuation downward, citing the loss of seamless intellectual property ownership and operational stability. The company's stock price plummeted, eroding millions in shareholder value almost overnight. Internal communications revealed mounting dissatisfaction among investors and major backers, concerned that Jason's cost-cutting gambit had inflicted lasting damage. Regulatory bodies escalated their actions as well. The SEC initiated multiple investigations focusing on alleged violations of securities laws, particularly regarding failure to disclose the contested patent ownership during merger filings. Cormier Tech was hit with fines approaching $3 million for inaccurate disclosures and inadequate internal controls. The Patent Office's inquiry further complicated the company's position, examining the legitimacy of ongoing patent assignments amid claims of ownership reversion. These regulatory pressures intensified scrutiny on the company's management and its handling of intellectual property assets. Media outlets specializing in technology and business reported extensively on the fallout. Industry analysts lambasted the leadership transition, highlighting Jason's reckless approach and the broader implications for corporate governance in family-run tech firms. The scandal became a cautionary tale about the risks of nepotism and the consequences of sidelining key technical experts. Public perceptions shifted, and Cormier Tech's reputation was significantly tarnished, affecting client trust and future business prospects. Within the company, additional employees came forward to report similar experiences of improper terminations and contractual breaches under the new management regime. These disclosures triggered internal investigations and legal inquiries into human resources practices, further straining the company's resources and morale. The human capital crisis compounded operational risks already exposed by system instability and patent disputes. On a personal level, the corporate crisis reverberated through the Cormier family. Media reports disclosed that the CEO, Martin Cormier, was navigating strained familial relations exacerbated by the public and legal fallout. Divorce filings surfaced, revealing tensions that paralleled the corporate upheaval. These personal dynamics underscored how intertwined family and business conflicts had become, complicating governance and decision-making at the highest levels. From a legal standpoint, judgments were issued affirming my claims. Courts ruled decisively that the timing of my termination constituted a breach of contract and wrongful dismissal. The $175,000 bonus was ordered paid in full, alongside damages totaling $1.2 million to compensate for lost patent royalties, legal fees, and reputational harm. The rulings reaffirmed the enforceability of the patent reversion clause and prohibited Cormier Tech from using patented technologies without my explicit license or compensation. These judgments also mandated the company to revise its HR and compliance policies to prevent recurrence. This phase of corporate reckoning was sobering, highlighting how a single premature termination, executed without due diligence or appreciation for contractual safeguards, could cascade into wide-ranging financial, legal, and reputational damage. For me, it validated the strategic patience and professional rigor I had maintained throughout the ordeal. The stakes had been high, but the legal framework and evidence-backed approach ensured accountability and restoration of rightful ownership. At the close of this tumultuous period, Cormier Tech was forced into a comprehensive restructuring to regain regulatory compliance and rebuild shareholder trust. The fallout served as a powerful lesson to executives and boards about the critical importance of respecting contractual obligations, maintaining transparent communications during mergers, and valuing the expertise of institutional knowledge holders. Jason's removal was not merely disciplinary, but a signal of the company's acknowledgement that governance failures had nearly derailed its future. While the company faced significant challenges ahead, my professional and legal vindication stood as proof that meticulous contractual planning, intellectual property management, and disciplined legal action can effectively counteract even abrupt and unjust corporate decisions. The aftermath demonstrated that safeguarding one's professional contributions through clear contracts and strategic leverage is essential in navigating the complexities of modern corporate environments, especially during transformative mergers and leadership transitions. The legal battle that unfolded after filing our lawsuit and regulatory complaints culminated in a series of court rulings that decisively affirmed my contractual and patent rights. The courts awarded me the full $175,000 bonus I was owed, recognizing that the deliberate timing of my termination violated explicit bonus vesting clauses in my employment agreement. More significantly, the rulings confirmed the enforceability of the patent reversion clause embedded within the patent assignment agreements, legally restoring ownership of the 12 key patents to me, the inventor, due to my premature termination. This restoration effectively blocked Cormier Tech from continuing to use those proprietary technologies without my explicit licensing, fundamentally challenging the company's operational and merger strategies. The $1.2 million awarded in damages went beyond simple compensation for lost wages. This figure included estimated royalties the company would have owed for the patented technologies had proper licensing been in place, as well as reimbursement for the substantial legal fees incurred throughout the protracted dispute. The court's assessment carefully analyzed the revenue generated by products reliant on my patented systems and factored in the reputational and professional harm stemming from the company's contractual breaches. This comprehensive damages award underscored the gravity of the company's violations and the importance of respecting employment and intellectual property agreements in corporate governance. This decisive legal outcome triggered immediate operational consequences for Cormier Tech. Without clear rights to the patents, which formed the bedrock of several flagship products, the company was legally prohibited from deploying, updating, or licensing the affected software modules. Their attempts to circumvent this by continuing to operate the systems risked further infringement suits, exposing them to additional financial liabilities and regulatory sanctions. This legal blockade became a critical bottleneck, effectively halting any progress toward completing the $420 million merger until these intellectual property ownership issues were resolved. Simultaneously, the Securities and Exchange Commission imposed substantial fines totaling $5 million on Cormier Tech. These penalties were levied for failure to disclose contested patent ownership and the abrupt termination of a key employee responsible for core intellectual property during the merger due diligence process. The SEC's enforcement actions also mandated comprehensive corporate governance reforms to enhance transparency around personnel decisions and intellectual property management. This regulatory intervention sent a clear signal to the entire industry about the consequences of neglecting contractual obligations and disclosure requirements in high-value transactions. Industry forums and professional conferences soon picked up the case as a cautionary example. Experts dissected how a single overlooked contractual clause and a premature termination decision could unravel a high-stakes merger valued at hundreds of millions of dollars. Board members, legal counsel, and senior executives from various companies studied the sequence of events as a lesson in corporate risk management, emphasizing the need for rigorous contract oversight and the integration of IP considerations into personnel decisions. Jason Cormier's leadership failures became a case study on the perils of impulsive cost-cutting without due diligence. The industry's reaction extended beyond academic discussion. Jason quickly found himself blacklisted from executive roles in other technology firms. His reputation, already tarnished internally, was irreparably damaged in the broader professional community. Recruiters and board committees viewed his tenure at Cormier Tech as a cautionary tale, severely limiting his ability to advance in the sector. This personal consequence reinforced the broader message that professional competence and respect for contractual and intellectual property frameworks are non-negotiable at the executive level. In contrast, my strategic and measured approach garnered recognition and renewed professional opportunities. Competitors and consulting firms, impressed by my comprehensive handling of the dispute, extended offers for principal consulting roles, valuing the rare combination of technical expertise, contract mastery, and legal acumen I demonstrated. These opportunities came with significant financial incentives and equity participation, reflecting not only my expertise, but also the credibility earned through navigating a complex, high-profile corporate conflict with professionalism and strategic foresight. Cormier Tech, meanwhile, was forced into a comprehensive restructuring to address the regulatory mandates and rebuild trust with shareholders and clients. This included overhauling HR policies, instituting more rigorous contract compliance protocols, and reinforcing transparency around intellectual property disclosures. The company's painful experience became a benchmark for best practices in corporate governance, especially within family-run and technology-driven enterprises, where the intersection of personnel decisions and intellectual property rights can critically impact valuation and strategic initiatives. While the situation at Cormier Tech remained turbulent, my professional standing emerged strengthened. The court judgments not only restored my rightful financial benefits, but also reaffirmed my ownership of the patents that underpin critical enterprise technologies. The legal blockade I established against unauthorized use of these patents gave me leverage to negotiate future licensing agreements on terms reflective of their true value. This outcome illustrated the power of meticulous contractual planning and the importance of combining technical expertise with legal strategy in defending one's professional contributions. The final impact of this phase was multifaceted. It validated my claims, imposed significant financial and operational costs on Cormier Tech, and reshaped industry perspectives on contract enforcement and intellectual property stewardship during mergers. My experience became a benchmark for professionals facing similar challenges, highlighting the necessity of detailed documentation, legal awareness, and strategic patience in corporate disputes. The case's evolution underscored that even within large organizations, individual contractual rights and professional diligence can decisively influence corporate trajectories and leadership decisions. Now, as a principal consultant with a 35% salary increase and equity stake in a promising tech startup, I've shifted from being an institutional employee to an independent expert, leveraging my intellectual property and professional expertise. This transition was not an accident or a mere stroke of luck. It was the outcome of a carefully executed strategy rooted in meticulous documentation, contractual mastery, and measured patience over many months. The $175,000 bonus I was rightfully owed, along with $1.2 million awarded in damages, didn't merely compensate me financially. They were a professional validation, affirming the value of 26 years of relentless dedication and innovation. Reflecting on this journey, it's clear that success didn't come from emotional reactions or confrontational tactics. Instead, it stemmed from a disciplined approach, systematically reviewing every clause in my employment contract, painstakingly gathering evidence of management's breaches, and collaborating closely with legal counsel to ensure each step conformed to professional standards and legal protocols. The patent reversion clause proved to be a linchpin, an often overlooked contractual safeguard that shifted control of critical technologies back to me, denying the company unauthorized use. This clause was my strategic leverage, transforming a seemingly abrupt termination into a powerful assertion of rights. What also made the difference was my commitment to preserving comprehensive documentation, system architecture diagrams, code repositories, email correspondence, and detailed contract archives. These weren't just internal records, they became my evidentiary arsenal. When the company tried to downplay the significance of my role and the proprietary nature of the technologies, these artifacts told a different story, one that courts, regulators, and industry peers could not ignore. The ability to demonstrate technical complexity and operational dependencies clearly was instrumental in elevating the dispute beyond a simple personnel matter to a substantive corporate and legal challenge. On a professional level, the outcome reshaped my career trajectory. The consulting role I now occupy not only rewards me financially, but also offers intellectual autonomy, allowing me to leverage the patents I rightfully own without corporate interference. The equity in a startup aligned with my technical focus further validates the strategic pivot from employee to entrepreneur and consultant. This new chapter underscores the importance of aligning professional expertise with contractual protections to maximize long-term value and control. Beyond personal gains, I recognize the broader industry implications. My case has become a reference point in professional forums and corporate governance discussions, illustrating how contract vigilance and intellectual property management can serve as essential tools for employees facing unjust termination or corporate mismanagement. It's a cautionary tale for executives and boards that underscores the risks of neglecting contractual obligations, especially when intellectual property forms the backbone of company valuation and strategic initiatives. Equally important is the professional lesson it offers about patience and strategic discipline. At every stage, from the moment of termination to litigation and settlement, I maintained a composed, methodical stance. I avoided public confrontations or emotional outbursts, understanding that professionalism and factual rigor would carry more weight in legal and corporate contexts. This approach not only preserved my credibility, but also demonstrated to peers and potential clients that effective conflict resolution in high-stakes environments depends on strategic thinking rather than impulsive reactions. Looking back, the entire episode reinforced the critical synergy between technical expertise and legal acumen. My deep understanding of system architectures and intellectual property intricacies enabled me to identify vulnerabilities and leverage contractual clauses that might otherwise have gone unnoticed. Coupled with Linda Barrett's legal insights, this combination became a formidable force that protected my rights and reshaped corporate actions. It's a testament to the power of cross-disciplinary proficiency in navigating complex professional disputes. Today, as I consult for a diverse range of clients, many of whom operate at the intersection of technology and intellectual property, I bring not only technical skill but also a hard-earned perspective on contract enforcement and professional leverage. My patents remain active assets, and the licensing agreements I negotiate reflect their true market value, a direct outcome of the legal precedents established in my case. This empowers me to contribute meaningfully to innovation while safeguarding the fruits of my labor. In this new phase, I continue to advocate for thorough contract review and intellectual property diligence. Whether advising startups or established firms, I emphasize the necessity of clear agreements, diligent documentation, and strategic patience, lessons drawn directly from my experience. The intersection of technology, law, and corporate governance is where modern professionals must excel to protect their contributions and navigate organizational complexities effectively. Ultimately, the $175,000 bonus and $2 million in damages are more than financial figures. They symbolize recognition of professional integrity, contractual respect, and the strategic defense of intellectual property. My victory was achieved not through confrontation, but through the disciplined application of expertise, rigorous documentation, and unwavering patience. It stands as a powerful example of how well-structured contracts and methodical professional conduct can safeguard even decades of dedication from abrupt and unjust corporate maneuvers. As I move forward, I remain grounded in the principles that guided me through this ordeal: precision, professionalism, and strategic foresight. These attributes transformed what could have been a career-ending setback into an opportunity for growth and renewed purpose. The lessons learned continue to inform my work and serve as a beacon to others navigating the complex interplay of technology, contracts, and corporate politics. In this journey, I stand stronger, not just for what I reclaimed, but for the professional mastery I demonstrated, an enduring testament to the power of contractual vigilance and strategic discipline.